Hello, welcome to the second part of section 161. In the first part, we dealt with subsection 1 of section 161. In the first part, we dealt with additional director and the details of roles and responsibilities, how to appoint, regularization, etc. of an additional director. Today in this session, we are going to deal with subsection 2 of section 161. It deals with an alternate director. Before we go into the subsection, let us see who is an alternate director. So, alternate director, from the word alternate itself, if you check the dictionary meaning, it means what? A substitute of someone. A substitute of a person is alternate. So, that is the same meaning that is applied in Companies Act. So, alternate director is a personnel who is appointed by the board of directors as a substitute to what? To a director who may be absent from India for a period which isn't it less than 3 months. Hello, welcome to the second part of section 161. In the first part, we dealt with subsection 1 of section 161. So, in that we saw about details about additional directors. Today we are going to deal with subsection 2 of section 161. So, as we all know, section 161 deals with appointment and qualifications of additional director, alternate director and nominee director, and it also gives some details about casual vacancy. So, subsection 2 of section 161 deals with alternate directors. So, before entering into the bare act, let us understand the dictionary meaning of the word alternate. So, the word alternate means what? A person who acts as a deputy or substitute. Like for example, you can say he shall be entitled to exercise the vote of the director for whom he is an alternate. Like this is a vocabulary sense. This is the same sense in which it is explained in the Companies Act. So, alternate director is a person who is appointed by the board of directors as a substitute to a director who may be absent from India for a period of not less than 3 months. Okay, when the director is away from the country for not less than 3 months, we appoint an alternate director. In this session, we will look at the role and procedure for appointment of alternate directors in a company. Let's read the first paragraph of the Bare Act, subsection 2 of section 161. The board of directors of a company may, if so authorized by its articles or by a resolution passed by the company in general meeting, appoint a person not being a person holding any alternate directorship for any other director in the company or holding directorship in the same company to act as an alternate director for a director during the absence for a period of not less than 3 months from India. So, according to the Act, let us see the main two ways by which the board may appoint an alternate director. So, first is by what? If the articles of association authorize, the board may appoint, and the second way is by passing a resolution in the general meeting. Okay. There is one more method, that is the alternate director can also be appointed by circular resolution. Okay, so the three things we have to remember is if the articles of association authorize, the board may appoint. Second thing, by passing a resolution in the general meeting of the company or by circular resolution. These are the three ways in which a company or the board rather may appoint an alternate director. Now, if the articles do not authorize or give power, the board may at any point of time amend the articles as required and authorize the board to give sufficient power to appoint an alternate director. We have to note one thing over here. We have to take into consideration the total number of directors when we are appointing alternate directors. Why is it so? Because the maximum ceiling as per the Act is 15 That is, a company should not have more than 15 directors. In case if it has to exceed 15, a special resolution has to be passed. So this is also pertinent to the appointment of alternate directors, as the company cannot appoint an alternate director if the company already houses the maximum number of directors. So the second part of subsection 2 is the person to be appointed. It is a person. So whenever we say person, he can be a member or a non-member. The person to be appointed as an additional director to the original director cannot extend his role by acting as an alternate director to another. So moreover, the alternate director proposed should not be a part of the company's current board members. That is, it says that the person to be appointed should not hold alternate directorship for more than one original director in the company. That is, in the same company. Okay. So this prohibits a scenario where a board has only one alternate director for two or more absentee original directors. But we have to also see, it also implies that the same person may be an alternate director of a director in any other company. And it is understood here that the proposed individual, that is the prospective candidate of an alternate director, should not be qualified under section 164 and 165 of the Act. The third important point to be noted here is absence from India. That is, an alternate director can be appointed only if the original director goes out of India for a period of more than 3 months. That is, an alternate director can be appointed as a director only on an occasion. Which occasion? Where a director of a company goes away from India for a period of 3 months or more. No other reasons would qualify for appointment of alternate directors. Furthermore, the alternate directors can be appointed at the mere possibility of the original director's absence. The company need not wait for the original director to leave and then search for an alternate director. Okay, so it is not necessary that the board of directors await the actual absence to make an appointment. Now let us see the first proviso. The first proviso says, provided that no person shall be appointed as an alternate director for an independent director unless he is qualified to be appointed as an independent director under the provisions of this Act. That means any person, that is any alternate director that shall be appointed instead of whom? Instead of the independent director. Note here, it is instead of the independent director. As we all know, to be an independent director, we have lot of criteria to be fulfilled. There are qualifications that is mentioned under subsection 6 of section 152. So, this alternate director, what he has to do? He has also to pass all these qualifications. If he is not a person of independence, then he will not be eligible to be appointed as an alternate director for an independent director. Okay, this is a very important point, so we have to note it over here. See, we just saw that if the original director is an independent director and if he moves out of the country, so what should happen? The alternate director should also have all the characteristics of independence. So what if the original director is a woman? So should the alternate director be a woman or not? So if you check the Act, nowhere it is mentioned, but with reasonable interpretation, we can say that generally the alternate director for a original woman director will also be a woman itself. Because as per the second proviso to section 149 subsection 1 read with rule 3 of the company's appointment and qualification of directors rules 2014, which comes under chapter 11, what does it say? That certain companies should have at least one woman director. So if the original woman director is the only woman director on the board, then obviously the alternate director should also be a woman. The second proviso to subsection 2 of section 161 says, provided further that an alternate director shall not hold office for a period longer than that permissible to the director in whose place he has been appointed, and shall vacate the office if and when the director in whose place he has been appointed returns to India. See, we have to understand few things over here. That is, the original director and the alternate director can remain on the board so long as the above position continues and there is no need of approval by the company in general meeting. But whenever the original director returns to the country, that is India, the alternate director automatically vacates his office and he may be appointed again when the original director leaves that country. Otherwise, he cannot continue as per the terms. Also, the return of original director to the state will be enough for the cessation of office of the alternate director, whether or not the original director attends a board meeting. See, returning to India is enough. It is not mandatory that the original director should attend a board meeting. E-Form DIR 12 shall be filed electronically with the registrar in respect of vacation of office and appointment on every occasion. The third proviso to subsection 2 of section 161 says, provided also that if the term of office of the original director is determined before he so returns to India, any provision for the automatic reappointment of retiring directors in default of another appointment shall apply to the original and not to the alternate director. That is, if the term of the original director expires when before the original director returns to India, any provision applicable for automatic reappointment of retiring director in default of another appointment shall be applicable only to the original director and not to the alternate director. We have to note something important with respect to notices and meetings, that the alternate director and the original director will be eligible to be received. That is, appointment of alternate directors wouldn't keep the original director sidelined. It is not that the original director will not be informed about the day-to-day affairs, or the information that he has to know will not be hidden from the original director. The original director as well as the alternate director is entitled to receive what notices of board meetings, and they may participate in it. This is especially relevant when a meeting takes place in a location where the original director is stationed. It may be noted that the original and the alternate director cannot attend the same meeting. The alternate director is especially appointed to fill the temporary void of the original director. For example, if an alternate director is present and the original director is stationed at Europe and the meeting is held at Europe, the alternate director cannot attend the meeting due to the availability of the original director. Let us see a few examples. In the first case, if the original director leaves to UK for say 5 months and an alternate director is appointed. The alternate director but obviously would be appointed for 5 months in this scenario. But contrary to what is planned, what is happening is the original director returns back to India in say 2 months. So what happens? Can the alternate director hold office for 5 months, or should he vacate office as soon as the original director returns? See, the answer to this is the original director, as soon as the original director returns to India, the alternate director has to vacate the office, that is as soon as the original director arrives. Let us see a second example. In the second example, what happens is the original director returns to India. He lands at Mumbai airport, say 8 a.m. on the 10th of September. So there is a board meeting on the same day at 9:30 a.m. But what happens is the original director is not in a position to make it. Here the question is, can the alternate director attend the meeting in place of the original director? So the answer to this is no, because it is mentioned that returning to India and it is not attending the board meeting that is to be considered. Let us take a last example, a scenario where Mr. A has gone to Germany for 2 years and Mr. B is appointed as an alternate director of Mr. A. So Mr. A is to retire in 1 year. So can the alternate director Mr. B continue the office? No, he cannot. He will vacate the office when the original director has to and can be reappointed in the later stage. Alternate director cannot be deemed to be reappointed. So with this we come to the end of the second part of section 161. We dealt with subsection 2 of section 161, which explains in detail the provisions appointment of alternate director, who an alternate director is, when can an alternate director be appointed, and so on. Hope this audio session is useful and the concept is clear. The rest of the part of the section of 161 we'll deal in part 3. Thank you.